Putting the politics aside, we break down the major legal case of Daniel Penny, the man who killed Jordan Neely on a New York City subway train. Former Watergate prosecutor and assistant U.S. attorney for the Southern District of New York, Nick Ackerman, comes on to discuss whether this is a strong case. I want to get into this story out of New York City that has a lot of people talking. It concerns the death of 30-year-old Jordan Neely. You probably already know this story, but I want to do a quick recap. So Neely was a homeless man who was actually acted as a street performer at times, impersonating Michael Jackson. A lot of people in New York City might have recognized him. But he was somebody who was also suffering from mental illness, and he had even agreed to 15 months of mental health treatment after a prior arrest. In fact, talking about his past criminal record, it's been reported that Neely has had 42 prior arrests in the past 10 years or so for offenses such as trespass, fraud, having an open container of alcohol, even assault. That includes an alleged assault of hitting a woman as she left the subway back in November of 2021. He was on a special New York City watch list as being one of the city's most at risk and was considered a danger to himself and others. Now, it will become a question about how relevant is that with what I'm about to talk to you about. Because let's fast forward to May 1st, where Neely was killed by 24-year-old Daniel Penny on an Uptown F train. Penny, a Marine veteran, choked Neely to death. And in cell phone video that has gone absolutely viral, you can see Penny holding Neely in a chokehold, and it's been reported that that hold lasted for at least 3 minutes. Penny turned himself in. He was arraigned in front of a judge last week on a second-degree manslaughter charge, which carries up to 15 years in prison. It is important to note here that the Manhattan DA's office opted not to take this to a grand jury. Instead, the DA filed a criminal complaint. This will have to later go to a grand jury for an official indictment. So Penny hasn't actually entered a plea as of yet. Now, the question, of course, is why would Penny do this? Well, here's where the story becomes very important. Reports indicate that witnesses on that train said Neely was shouting, that he was hungry, that he didn't care if he died, and at least one witness said to the media that he appeared to be a threat. However, as far as we are seeing, no one has come out and said that Neely actually physically attacked or hurt anyone. Prosecutors allege that that is when Penny approached Neely from behind, put him in a chokehold, took him to the ground, where, as I said, he subdued him for several minutes. There have been a number of protests and demonstrations in the wake of Neely's death. We've seen this in New York City, but there have also been supporters of Penny. In fact, his defense fund has grown to over $1.5 million at the time of this recording. And now that Penny is facing this criminal charge, what could be in store for him? How strong is this case? Well, let me bring in right now lawyer Nick Ackerman, who is a former Watergate prosecutor and assistant U.S. attorney in the Southern District of New York. Nick, thanks so much for taking the time.
Thank you for having me.
Let's first start off with the idea that this was brought not in front of a grand jury, but this was filed a criminal complaint by the DA's office. I am told that's not that rare. But you could see in a case like this where there has been so much attention and some would say political pressure, do you think it's unusual that this wasn't taken to a grand jury first?
I don't think so. I think that's pretty standard, considering the timing and everything. It does take time to put this before a grand jury. And ultimately, the DA's office might decide that they're going to present all the evidence to a grand jury and actually let a grand jury decide whether there's sufficient evidence to indict. The problem with this case is it is very factual intensive in the sense of, did the individual Perry, who subdued Neely, really have a belief that this gentleman really posed a risk to other passengers on the train? I mean, that's what it comes down to. Was there a reasonable belief, and was the force that was applied reasonable under the circumstances? I mean, this is a very difficult case to really come to conclusions on just based on press reports. This is the kind of case where you really need witnesses before either a grand jury or ultimately a trial jury to determine whether or not there should be criminal liability imposed here. You know that this was not a case where this particular individual acted on his own. There were two other passengers who assisted in actually keeping this man down and from doing anything further. So it's really a matter of kind of understanding what happened as best you can. I mean, this is not an easy situation because it obviously happened in a matter of minutes. People's memories are not perfect.
Right.
But I think this is what our legal system is about. This is what the rule of law is about.
Okay, so let's break some of this down. Okay, let's break some of this down. Let's assume that Penny and other people on that train felt that, let's say that Penny and other people on that train felt that Neely was a threat. Okay, let's assume that fact for a second. The problem, I think, for Penny is the amount of time. So there would be, I would imagine, perhaps justification to put him on a chokehold, maybe for 10 seconds, maybe for 15 seconds. But if it goes to 3 minutes and even beyond that, and we know that he is the cause of that death, right? The medical examiner came forward and said that Neely died from compression to the neck. That amount of time, I'm not sure how you justify it. What would be a defense argument for that amount of time?
I think the defense argument would be that this all arose in kind of a situation where this was not a individual who was trained to basically subdue people on a subway, that he was acting as a private citizen, and that he did the best he could under the circumstances. And yeah, he did it for a longer period of time than was necessary. I mean, that will be the defense argument. On the other side of it will be, just as you said, he should have just imposed enough force to make sure that the person couldn't do harm to anybody, could have done other things besides the chokehold to subdue this person. But again, this is a situation that happens very quickly. People are making instant judgments, and it's a hard case to actually decide unless there's some other facts that would get somebody to believe that, they're really, that Neely didn't do, was doing what he was doing just because he was mentally ill. I mean, people don't know whether or not someone's mentally ill.
Right. Okay. I'm glad you mentioned that. I'm glad you mentioned that. So all of Neely's prior arrests, all of his mental health illness, unless Penny knew that, isn't all of that irrelevant? Because he didn't know that this guy had, he didn't know that Neely had any history of violent behavior. So I think all of that is irrelevant. I just brought it up to give everybody context.
Well, it is irrelevant because Neely, he did not know all of that, obviously. But the fact of the matter is, he was adjudged, as you said before, to be dangerous to himself and others. And if I were his defense lawyer, I think I'd be putting that evidence in because somebody somewhere along the line, who was probably a doctor, perceived that fact, which would support, the defense in this case. This is not like the Bernard Goetz case that occurred in the early 80s, where an individual was acting as a vigilante, carrying a gun on him, and just decided to shoot 4 individuals. It's a lot different. And so the facts here are extremely important. And the only way you come to a decision that is just is to really put all of those facts before either grand jury or a trial jury.
Okay, so let's also talk about the fact that he's charged with second-degree manslaughter. My understanding is that is a recklessness standard. In other words, Penny knew that what he was doing could engage in, it could result in serious injury or death, and chose to disregard that substantial risk. And if he's a Marine veteran and has training, I feel that puts him in an even different position. Now, do you think second-degree manslaughter is the appropriate charge here, and do I have the law right?
I think you have the law pretty much spot on. I would say you're right. It's really a question of, what did Neely think at the time? Obviously, 2 other passengers must have thought the same thing, or they wouldn't have helped Penny in subduing Neely. So it's a complicated case from that standpoint without knowing everything that occurred. I mean, all of these facts you mentioned are all relevant to a determination of whether or not the charge is justified. We
I
just
guess
don't know.
I guess the question I'm asking is, do you think that the charge is too severe or not severe enough? There's criminally negligent homicide, but we know that from Dante Mills and Leonard Edwards, who are representing the family of Jordan Neely, they feel a murder charge would have been appropriate here.
Well, to say this was a murder charge is very difficult. I mean, it certainly wasn't first degree. It wasn't premeditated. This all happened so quickly. In terms of second degree murder, again, he does have a somewhat viable case of self-defense and defense of the others on the subway. Manslaughter is probably right, but again, as you pointed out before, this has not gone before a grand jury yet. This was done on a complaint by the DA's office, and that would be something that really the grand jury should decide. I mean, they should look at all of the facts surrounding this. They should bring in as many of the people that were on that subway car as possible to get their testimony. And based on those facts, really should form the basis for any kind of criminal charge here. That's what a grand jury has to do. And I don't think the DA's office was really in a position to come up with the absolutely correct charge to fit the facts of what occurred here at this point in time.
And at the time of this recording, I am not aware of any other arrests in connection with Jordan Neely's death. You had mentioned that other people participated, not choking Neely, but, you know, they were holding him at a certain point. Do you think that they will face charges at a certain point?
It's possible. But again, I mean, I think what the DA did is basically put in a placeholder by bringing this based on a complaint, because it's going to take time to get all of these witnesses into a grand jury. It sounds like that a lot of the people who are on that subway car have already come forward. They know who a lot of these people are. And all of these people will have to go into a grand jury and describe exactly what happened. And based on those facts is how the DA and the grand jury will really inform a decision on what actual charge ought to be brought, if anything.
And real quick, let's just talk about this. If Neely is screaming and he's shouting and he says, "I don't care if I die," but he doesn't make any physical contact with any of the people on that subway car, would at any point that provide justification for Penny to put him in a chokehold if there was no physical threat? Let me put it this way. If he never made physical contact, is the mere utterance, the mere shouting of words enough to use physical restraint?
I guess it all depends on how it was shouted, how it was done, who it was directed to. I mean, all of those are the factual questions that a grand jury and the DA's office ought to be examining super carefully.
All right, Nick Ackerman, thank you so much. We could obviously get into the political side of this. I choose not to. I wanted to focus on the law because I think the law is the most important aspect in this case. That is what is going to guide the decision, and we'll see where it goes and see where it progresses. Nick Ackerman, thank you so much for taking the time.
Thank you.
And that's all we have for you here on Sidebar, everybody. Thank you so much for joining us. Please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.